I'm your host, Hillary Bricken, and this is the Cannabis Law Now podcast, where we regularly discuss issues related to the cannabis industry, including investment, day-to-day operational issues, and potential reform on the horizon that will impact all cannabis businesses and investors in the United States. Welcome, everybody. On today's episode, I have one of my esteemed colleagues here at Husch Blackwell with us. We have Yufan Wong. Yufan, based out of Denver. How you doing?
I'm great, Hillary. How are you?
I'm doing well too. And we have you on the podcast today to specifically talk about, which may be the majority of cannabis companies, unless they've really been paying attention, they don't know about it, but it's the application of the Corporate Transparency Act to them, their existing businesses, new businesses, joint ventures that they seek to start. And before we get into the Corporate Transparency Act, which I'm going to call the CTA, why don't you give us and our listeners a little bit on your background? You're a corporate M&A and securities attorney, but what does that really mean in the context of serving your cannabis clients? And just give us a little bit of a history of your practice before we launch into CTA.
Yeah, sure. Thanks again for having me. So I have been practicing in the cannabis field and also with Husch Blackwell for 5 years. Prior to that, my background was in general corporate law, private equity, public and private acquisitions, investments, and so forth. I was actually at a big US law firm in Shanghai, where I was helping a lot of American companies invest into, the Chinese PE space, a lot of biotech work. I actually sought out Steve Levine and Marshall at Husch Blackwell because I really wanted to get into cannabis, and I interviewed them from China, and here I am. So yeah, a little bit of an interesting story. So yeah, I kind of bring, just a general corporate skill set to the cannabis space. Since I've been at Husch and in Denver, I've done a lot of transactions for, all the big names here in Colorado. One of the highlights would definitely be the sale of LiveWell to PharmaCann a couple of years ago, which was at that point the biggest cannabis deal in the nation at over $1 billion. So my specialty is generally in acquisition type work. So selling and buying dispensaries, licenses, and that stuff. And also equity investments. We see that a little bit less, of course, in the cannabis space, but I also have kind of a non-cannabis practice where I do a lot of similar types of work in other industries.
And I have to say, cannabis is volatile. It's been that way from the jump. It's highly unpredictable, at times arbitrary state-by-state patchwork quilt of regulation that sometimes undermines or definitely informs all of these transactions, including the M&A. The only thing I could think of that might be more volatile and scary and precarious would be doing business in China. And I can say that because my last law firm had a big China practice. And I do recall many years ago, they were getting their forms rejected because they didn't fill them out in blue ink, even though it did say blue or black ink on the form, but on that day, black ink wasn't being accepted. So I can only imagine the volatility that you've seen in your past and that you're quite conditioned to be able to help cannabis companies.
I'll say it's very relationship based. One of the deals I actually did was helping a state-owned enterprise, which is an entity created by the communist government, in the acquisition of a semiconductor manufacturer in the US. This was right before the Trump presidency and probably one of the last deals of that nature that will ever be done. So, yeah.
Wow. Yes, I do think that China transactional attorney is fit to practice in the cannabis industry in the US more than probably the majority of other candidates. Okay, so let's talk about the CTA. As a corporate lawyer, and I have a corporate practice as well, this is infecting our practices with our clients, unless they're exempt, wanting to start new entities, or even if they began entities last year, it could potentially apply. Can you just give us an overview of the CTA, assuming that a lot of these listeners maybe haven't even heard of it, let alone delved into its elements?
Yeah, sure. I think so. I'm just going to give you a little background. The three biggest takeaways I would say are that, one, the act, it came into effect January 1st of this year. It applies to entities created before and after the effective date. And when I say entities, I mean virtually every single kind of entity you're going to be working with: corporations, trusts, limited partnerships, except for a few very narrow types of entities like common law trusts that we don't see much in the cannabis space. Your entity is probably going to be affected unless there's an exemption, which I'll talk about in a second. The second most important thing is that this requires reporting of natural persons. So when you're filing as a company, you're going to have to list your individual beneficial owners Doesn't matter if you own your primary license entity through a number of LLCs or partnerships or whatnot. It goes all the way to the top. Third most important thing is the timing aspect. For entities created prior to this year, you have until the end of the year to file this report and comply with the law. If you're creating a new entity going forward, you have 90 days to comply. That means the first batch, if you create an entity in January and you haven't reported yet, technically you're in breach of the act, the CTA, I'm sorry. And then I guess I'm just looking at a fourth one in, and there are criminal penalties involved, up to 2 years imprisonment for a willful violation. So this isn't just like a slap on the wrist. There could be, very strong potential penalties. So I'm just going to keep moving forward. A little bit of background. This was actually created as part of the Anti-Money Laundering Act of 2020. And the purpose, you hear anti-money laundering and cannabis, you might be a little spooked. The purpose of this was kind of in reaction to the Panama Papers back in 2016, just a concern by the U.S. government and Treasury with the particular use of U.S. entities as shell companies for, illicit activities, including money laundering and all that good stuff. Unlike a lot of other countries, our entity creation system is state-based. So there's no federal registry of beneficial owners. Most states don't even require you to report your owners. It's just an incorporator. So that's why Congress saw fit to pass this law. Moving to a few other concepts, there's kind of three things you need to report on. One is the company itself, the reporting company. So like I said, pretty much every single entity, no matter where it is in your chain of ownership, is going to be considered a reporting company unless it meets an exemption. There are 23 exemptions. Most of them do not apply to the cannabis industry. They are for industries that are otherwise regulated by Treasury, like private investment advisors, banks, Commodities Exchange Act registered participants, stuff like that. The biggest one, though, that would apply to the cannabis industry is called the large operating company exemption. And that basically says if you're a large, legitimate company with operations in the US, then you don't have to report. And the requirements for those are, one, you directly employ 20 employees. And that's important because if you have an affiliate that employs 20 employees, it doesn't count. Number two is you filed the tax return in the past year showing 5 million or more in gross sales or assets. I interpret that as basically line 1A on the relevant form. Three is you have a physical operating presence in the US. I think that the second and third probably will not be an issue for most of our larger cannabis clients, especially having a physical presence. But because of the nature of how companies are structured, the employment part might be an issue because you're not directly necessarily employing 20 employees. It might be an affiliate. That's a reporting company. And then what the reporting company also needs to report on are its beneficial owners. And those are individuals who directly or indirectly exercise substantial control over a reporting company or who own or control at least 25% of the ownership interest in the reporting company. Substantial control just means, your managers of your LLCs, but it also includes your senior officers, like your C-suite and your GC and people that act in that capacity. The ownership requirement is direct or indirect, meaning that if you're at the top of, a chain of corporate entities, you're not just reporting your sole member LLC, you're going all the way to the top to the human that owns interests. So it could be kind of a math problem. And this is really, in my opinion, the hardest part about figuring out this law is who the beneficial owners are. It becomes a math problem sometimes. And also, you're looking at people that might not be officially listed as an owner, but who nonetheless exert control. So yeah, that's kind of a quick and dirty overview. There's obviously a lot of other issues there, but wanted to answer that question.
I appreciate that overview. Obviously, the state licensed cannabis industry is no stranger to copious amounts of disclosure. And in the cannabis industry, from the regulatory perspective, these quote unquote owners, whether they're identified as true parties of interest, beneficial owners, whatever the term of art is, similar, right? Where a certain position in the cap table or this idea of direction, control, and management can trigger disclosure. When you say substantial control under the CTA, did Congress define that term, or is it left undefined to be determined by whatever body is going to enforce this? And before you go there, who is enforcing this?
Yeah, good question. This is actually enforced by FinCEN, which is the Financial Crimes Enforcement Network. They're kind of like an arm of Treasury, and they're, as implied by their name, their mandate is mostly dealing with financial crimes, like with banks. So if you've heard of the CDD, the customer due diligence requirements for banks, that is a FinCEN concept, and they've actually applied it to the beneficial owner definition here. So they're the ones enforcing it. And sorry, what was your second question?
When we talk about substantial control, because this is where my cannabis clients get caught in a way where these regulators are wise enough not to define it because they know it when they see it. And to your point, you may have substantial control despite your title, and you may not be listed in the C suite. Did they define substantial control in the context of the CTA?
They do actually. It's a pretty dialed in definition. So there's four parts. One is a senior officer, and they give examples of that. They say specifically presidents, CEOs, CFOs, COOs, and general counsel, or anybody that acts in that capacity. So, those roles are often associated with a corporation, but you could have a similar role in an LLC besides a manager. So anybody that acts in that capacity. Second part of that is anyone having the authority to appoint or remove a senior officer or a majority of the board. So to me, that's kind of duplicative of the ownership requirement because that implies to me an equity holder or a board member. There was some debate about, well, do you have to list every single person on the board? And I think it's pretty unequivocal that you do, even if you have a 35-person board, right? That one person could be casting the deciding vote. So over major, decisions in the company. Number three is anyone who has substantial influence over important matters. And lastly, it's anyone who has any other form of substantial control. And those to me are a catch-all. They could include everybody. I kind of think of the last two as, I like to say, the Tony Soprano rule, where I don't know if you guys have seen Sopranos, but he had that deli that he used to always be outside of, right? Like drinking his espresso. And he definitely was not on the title of that deli, right? But he exerted a form of substantial control over that deli. Like he definitely was running things, but maybe not in official capacity. And they really, FinCEN really added this catch-all definition to catch the bad actors who are otherwise not in the books. Begs the question, if I were Tony Soprano, why would I report on myself? But that's another issue.
And this also often comes up with cannabis companies, management companies. And and I think we all know if you've been in the sector why you would have a management company. There are many good strategic reasons, but oftentimes it is nefarious and for reasons that cut against transparency, etc. And we're just talking about the formation stage. So I form my new co, I'm not exempt, I have to report. If I know I'm going to have a management company come in and run my day to day, oftentimes, like what we see with casinos are rarely run by the people who actually own them. They bring in a top tier management team that specializes in security and gaming. Is that management company disclosable in that context because they will be exerting substantial control over day to day ops?
Absolutely. So after your initial filing, you also have a duty to update any information within 30 days. So back to your fact pattern, right? Let's say when I submit my initial report, I might not list them as a beneficial owner. But once I sign that management agreement, I have to list not just, not the management company, but the people actually running that company, the individuals that are exerting substantial control through that management company. And also beyond that, the management company itself would be a reporting company. So they would also have to disclose their beneficial owners. And hopefully those two reports align, or otherwise there's something wrong there.
And are states adopting mini CTAs to remain lockstep with the feds here?
Unfortunately, yeah, that's a very good question. New York just passed their own, it's called the LLC Transparency Act. And in many ways, it's quite a bit worse than the federal law. So it doesn't take into effect until January 1, 2026. It applies to just LLCs as of right now, but LLCs formed or qualified to do business in New York, which is, I would say, the majority of companies in the US. And their reporting is, unlike, for example, state blue sky laws that are preempted by, federal laws. This is in addition to the CTA. So you're going to have to make a report under the federal CTA and then also the New York Transparency Act. And they have some quirks too. They rely on a lot of the same concepts as the federal CTA. They rely on the same definitions of substantive control and beneficial owner, for example. But one thing is, under the federal CTA, if you're exempt, you just don't file. You don't report it. It's a Scout's honor almost. You have to certify which exemption you qualify for. The good thing is there are only civil penalties involved, but still an additional thing. And that's just New York. California has two similar acts that are in its legislative body. Maryland also has a similar act going through, its legislative body as well. And then a bunch of other states are considering proposing these laws. I think as a corporate lawyer, we're all worried about Delaware, right? What if Delaware does this? And pretty much 60% of American companies will have to report there as well. So with the proliferation of these state laws, I'm hoping that, again, there will be a blue sky law like concept where the federal law preempts individual state ones. But right now, it looks like you just have to make a bunch of filings for every state and jurisdiction you're in.
Yeah, and I just want to emphasize for the cannabis companies, this will be maybe the third or fourth iteration of disclosure, which is going to differ from your cannabis disclosures with your regulator because it's just a different set of priorities and reporting obligations. The substantial control issue alone is going to expand under the CTA, whereas most states in the cannabis industry would dictate that it really only goes to this meaningful control and authority without the catch-all. So that'll be a complicating factor. Now let's talk about our large operating companies, our friends commonly known as the multi-state operators. On its face, seems like they're not disclosable because they're probably netting the required revenue per year and they've got 20 or more employees. But if they start subsidiaries or they've got these related or affiliate companies that often hold a variety of assets, real estate, intellectual property, equipment that they deploy to their cannabis asset companies, are those companies going to be reportable despite the fact that maybe they're wholly owned subs?
Great question. So one of the exemptions I declined to discuss a second ago was the subsidiary exemption. And that exemption is that for certain exempt entities, their subsidiary, including the large operating company exempt companies, their wholly owned subsidiaries are also exempt from reporting. I stress wholly owned because if you have like a 99.9% owner and a 0.01% owner, that subsidiary is not exempt if the 0.01 is not exempt. And as is common with these MSOs, right, the cobweb of ownership structures will mean that a lot of those subs are not exempt. And then also, just to put a finer point on it, we say a company, right, reporting, it's each individual entity in the company group. So it's not just, the MSO at the top, right, or whatever. It's every single entity that is in that network is reporting. So if you have a real estate owning company, that has to report. If you have a company that holds your IP, that has to report itself. And because of the direct 20 employee requirement, a lot of those entities are not going to qualify for either the large operating company exemption or the subsidiary because they don't meet it's a entity by entity call. For the $5 million gross sales or tax, you can consolidate, entities. So if you're filing as a consolidated group, then each single entity in that filing group can avail themselves of that. For example, a disregarded entity cannot because it doesn't file taxes. It relies on a parent to do so. A lot of kind of fine kinks in this exemption that you definitely should have someone analyze closely.
Wild. It's just wild. FinCEN, you mentioned the Financial Crimes Enforcement Network. They issued guidance to financial institutions back in 2014 that essentially enable those institutions, despite anti-money laundering laws and the Bank Secrecy Act, to service these federally illegal drug traffickers as the federal government would deem them under the Controlled Substances Act. Those guidelines hinge on these KYC rules, these know your customer rules, an enforcement memo from the DOJ that no longer exists, and they're very robust in kind of keeping eyes on cannabis operators, essentially dragooning these financial institutions into doing the dirty work of the feds. And there's a whole suspicious activity report filing system that was created specifically for cannabis companies out of those guidelines. Do you think there's an interplay here? And this is speculative. You can just say, I don't know if you don't know, but if you have an opinion, please share. Do you think there's an interplay here between those guidelines and the CTA, given that it's the same arm of Treasury that's going to be the watchdog, and that this is going to further, maybe hurt is a strong word, but further impact these mom and pop cannabis companies, right, rather than the MSOs?
I do. I don't think any of this was, targeting the cannabis companies. I think it might just be an unfortunate byproduct, but I think there's a possibility, and here's why. So the law passed by Congress had three parts. One was to kind of define the beneficial ownership that needs to be collected. Two is which entities enforcement authorities can access information. And number three is actually requiring FinCEN to update their beneficial ownership rules, CDD rules, to match the CTA actually. So that KYC stuff is going to undergo a change to have their substantial ownership definition match this one. So there's an interplay there where it seems like FinCEN is kind of refining the concept of a beneficial owner and who needs to be reported and who needs to be monitored, and then kind of applying it retroactively to its other laws. That's definitely somewhat concerning, I'd say. And number two, and we haven't really talked about this much, is the repository, because all this stuff is going to be stored at FinCEN. And the good news is that it's not going to be public information. It can't be subject to a FOIA request. Not, Joe Schmo off the street can't just like log into FinCEN's website and check the ownership of, some big MSO. However, there are a lot of rules about who can access it. There's a pilot program right now where it's just federal law enforcement. So, FBI, Homeland Security, NSA, I'm assuming at some point, maybe CIA, I don't know. But it's going to be eventually rolled out to other regulatory bodies, to state and local governments who, based on certain access parameters, and then to the banks, and then even to foreign authorities. Those foreign authorities cannot directly access the database. They have to submit a request to a U.S. law enforcement authority, which is obviously good. But now you have this giant database, theoretically, of most medium to small companies in the United States with all its owners. And I didn't mention this before, but you're having to submit your driver's license, a copy of your driver's license, your street address, your real name. All this stuff is going to be stored and associated with the company. So right now, of course, federal government is not actively, enforcing the CSA. But if for whatever reason, one day, legislation does not go the way we all hope it does, the federal government now has access to this gigantic database where theoretically cannabis companies have put forth their owners' names and addresses and driver's licenses, which is accessible to, your state regulator theoretically at some point. So given that cannabis is still, technically and very really, very actually illegal, I think there's potential for abuse here.
I'm with you. In the past, I've done a good amount of foreign direct investment into the cannabis industry, and rarely would you see foreigners from a multitude of reasons directly invest in cannabis companies. It's too on the nose for things like immigration and violations of rules in the home country. So they often place their investments in ancillary companies, right? And when we say ancillary, we mean the classics: IP, real estate, equipment, consulting, etc. All of those companies will be on the hook for this reporting now. And oftentimes you would see in their corporate filings, it'd be a situation where they maybe tell some of the truth, but not all of the truth, but by omission, it's still valid in that they're a real estate company. But they don't go so far as to say, well, we're a real estate company that leases exclusively to cannabis businesses, right? With this type of reporting, do you think there's going to be a chilling effect on foreign direct investment? Because now where maybe you could have skirted the state regulator, right? Because state regulator only cares about the cannabis company. You are going to be in the crosshairs of FinCEN if you're not exempt otherwise.
That's a really good question. I've only thought about this really in the concept of data privacy laws, but I want to kind of, explore this because not theoretically, actually, if you're a foreigner and you're a beneficial owner, you're going to need to be reported to FinCEN. So let's say you're, an investor from Kuwait or Saudi Arabia, where cannabis is extremely illegal, right? You will, if you qualify as a beneficial owner of of a U.S. cannabis company, you will have to be reported and your information stored in the FinCEN database, including, for foreigners, a physical, a photocopy of your passport, along with your name and your address and all that. So FinCEN now has information. Let's say at some point when they roll this out to foreign law enforcement agencies, the Kuwaiti authorities say, hey, this guy's suspicious. Can you, because this is a violation of our laws for him to even own an interest in this company, can we access your database and check the records? Now, there's all sorts of reasons perhaps why we wouldn't want to do that as the US, right? But theoretically, since we do have that database, let's say, we want it to be on better terms with that country, we could give them full access to see every single one of their citizens who own an interest in alleged cannabis companies. So I think there are some issues there. The data privacy issue I was alluding to is for a lot of countries, you have to give consent to transfer information across borders. What is consent? It's just merely giving you the information. Is that consent? Do you need something affirmative? All sorts of issues there when you're talking about transferring information across borders and storing it.
And to kind of round this out, before I let you go, because this is fascinating to me in that it's even more surveillance, more transparency in an industry that comes from a paranoid place already, and it applies to everybody. Number one, the softball question. Just because cannabis is federally illegal, that does not mean that you don't comply with the CTA, right?
Absolutely. I guess there is a question of how are they going to go after the 32 million entities they think need to report. If you're aware of this law, which unfortunately now you are, and you don't report, then you have willfully violated this the CTA, and you could face 2 years in jail.
Fabulous. Number two, is anybody challenging this? Because I don't see corporate America loving this, especially with the entrepreneurial spirit in the United States, where we don't want to be bogged down by regulatory or red tape, public health and safety stuff set aside, right? Like FDA and all of our consumer protection stuff. Is anybody going to overturn this? Is this going to last?
Actually, that's a very good and timely question. So the NSBA, the National Small Business Association, I believe they represent around 200,000 small businesses in the US. They sued in the Northern District of Alabama, and they actually won. As of March 1st, a judge in the Northern District of Alabama found that the act was unconstitutional based on Congress's Article 1 powers, which is the Commerce Clause. I'm sure you guys have heard about the dormant Commerce Clause issue with, New York and Michigan and so forth. This is the, non-dormant Commerce Clause. And the judge basically said the Congress exceeded its Commerce Clause authorities, and this law is unconstitutional. However, not all puppies and rainbows. The judge found that it only applied to the specific plaintiffs in the case. So FinCEN issued a report the day after saying, okay, the members of the NSBA, as of the date of the decision, don't need to file. The implication being that everybody who joins afterwards and everybody else in the world must report. There's another case, which is the NSB, the National Small Business Association of Michigan, which is like an affiliate entity. They're also suing. That's kind of still going through the courts. However, I'm as surprised as you are that there are no other major challenges, one, to this law. And two, based on this holding, it doesn't apply broadly, right? It seems like you as an organization, maybe like, the NCIA would sue, but that would only apply to the members then. There's no kind of broad-ranging relief right now. And then 10 days after that decision, Treasury already, appealed the ruling to the 11th Circuit. So I was, kind of before this decision came out, I was kind of telling clients, oh, just wait and see, maybe someone will overturn this. But even though it was overturned, the decision is so narrow that I don't see how useful this would be to everybody else.
Well, fascinating. All right, folks, the CTA is here to stay, comply or perish. And Yufan, thank you so much for your time and attention and insights. It was both wonderful and terrifying.
Thank you, Hillary.
And that concludes today's episode of the Cannabis Law Now podcast. Until next time, stay alert, stay alive.